Good evening and welcome to the Town of Gibbons Land Use Bylaw Modernization and Focused Land Use Bylaw Review online open house. This open house is being recorded for those who are unable to attend so that it can be watched at a later date in the convenience of your own home. So the presentation this evening will take you through what a land use bylaw is. It'll provide a little bit of information about the town's current land use bylaw, the focus of the modernization, objectives, and the process of the project up to date. We'll conclude with a summary of the proposed changes to the draft land use bylaw and the next steps. So what is a land use bylaw? A land use bylaw is a mandatory document or bylaw that all municipalities in Alberta must have. It establishes processes for development permit applications, for subdivision, for notification and enforcement, and the appeal process. It establishes regulations for specific and general types of development within the town. And it divides the town into different land use districts. Within each of those districts, it identifies permitted and discretionary uses that are allowed. Often for municipalities, this is the longest bylaw that they have, and it is a bit of a complicated bylaw in part because of its length, but also in part because of the complexity of the things that it has to address. What a land use bylaw needs to include within it is identified within the Municipal Government Act, which is a piece of provincial legislation. And within that legislation, it identifies must requirements and may requirements that all land use bylaws must cover in some capacity. So a little bit about the current land use bylaw. The land use bylaw that's in effect today was originally adopted in 2006. It's been amended a number of times, approximately 50. And there isn't a consolidated version of the land use bylaw that is available on the town's website. So this makes it a very difficult document to understand and to use for members of the community and developers. Currently, the land use bylaw, because it's a little bit older and it predates current or recent changes to the Municipal Government Act, is inconsistent with some of the new provincial acts, regulations, policies, and then references to different departments and agencies. The land use bylaw also hasn't been updated yet to be consistent with the newer municipal development plan and intermunicipal development plan adopted by the town. And then it also hasn't been updated to reflect the town's recent annexation. So there's a number of changes that have occurred since 2006, and the purpose of this project is to ensure that the town's land use bylaw going forward will be consistent with those different changes, which will make it a much easier to use document and more consistent with the requirements that are in place today. So the focused review objectives that were identified at the onset of the project were to ensure consistency with updated legislative requirements and regulations, to ensure consistency with the town's high-level statutory plans, to incorporate those amendments to the land use bylaw that had been approved by council, to reflect current property boundary mapping information, to reduce red tape where possible by identifying application information that may or will be required with different applications for development, to address modern land use and development pressures within the town and the region, and to enable a wide range of housing options through the town to support anticipated demands or needs within the community. Additionally, the review looked at how to encourage development of a greater mix of uses within the downtown area, and consolidate where appropriate different land use districts to try and reduce the document length and complexity. To date, the project team, which consisted of planners from Municipal Planning Services or MPS, and town administration with input from council, has met regularly to discuss specific land use and development matters within the town. MPS prepared a recommended changes report in the spring of 2024 for administration to review and update council. Then the first draft of the land use bylaw was prepared for administrative review in the summer of 2024. The draft was updated to reflect input from administration. And in-person and online review meetings took place in order to ensure that the draft reflected the specific needs of the community. And then the draft was presented to council in December of 2024 for review and feedback. After the meeting with council, additional changes were made to the land use bylaw, the draft land use bylaw, to reflect their input. And then the document was posted for the community to review in advance of this public open house. So we'd like to provide you with an overview of some of the changes that have been proposed in the draft land use bylaw. There are some sections that are new sections for the land use bylaw. They don't exist in the currently approved land use bylaw. And then there's other sections where revisions have been proposed that alter or improve or are intended to ensure that the regulations in the document will meet the needs of the community. So the first thing that we added to the document is a list for amendments to go into. So when the document is approved, it'll be empty, and then as the document is updated over the next few years to reflect changes to the land use bylaw proposed by community members or developers, there'll be a list that tracks those amendments, which should make it easier to identify and track those changes. The draft also includes a guide at the beginning of the document, which is intended to assist the reader with understanding how the land use bylaw works. Because it is such a long bylaw, and because it is a bit of a complex bylaw, it's important to note that you can't read one section alone. Often, in order to understand the process and the requirements for different types of development applications, there are a number of sections that have to be read together to fully understand what the requirements are and how to make application and what those applications should include. Then we get into the procedural components of the land use bylaw. Part 1 of the land use bylaw provides information about general administrative procedures. It includes a purpose statement for the land use bylaw and identifies the area that it covers, which is all of the land within the boundary of the town. This section indicates the commencement and repeal dates for the bylaw, the area that it applies to. There's a conformity, compliance, and severability clause, and then it explains the role of the figures in the document. Section 2 provides information about who has authority to make decisions related to matters that pertain specifically to the land use bylaw. It identifies the roles and responsibilities of council, the development authority, the development officer, the designated officers, the subdivision authority, and the appeal board. Some of the changes that we flagged for your attention as you are reviewing the land use bylaw are that in this document, one of the changes that's been proposed is to enable the development officer to issue decisions for development permit applications where a variance of up to 10% has been requested by the applicant with their development permit application. Currently, all decisions for development permit applications that require a variance are required to be approved by the development authority, who in the town of Gibbons is the town CAO. So this would enable a quicker turnaround for applications where a variance is required in order to facilitate the development on the lot when the variance requested is very small. And the hopes with this change, why it's being proposed, is to be able to speed up that process so that we can try to reduce a little bit of red tape and expedite timelines and processing of files. The next section is the interpretation section, and this is the definitions section. The definitions of the land use bylaw are really important. When they are crafted, the way that they should be crafted, they provide a lot of assistance in interpreting the way that terms are used within the land use bylaw. In land use bylaws, there are some terms that are defined in a slightly different way than they would be in common usage. And so it's important that those terms be defined within this section of the bylaw to make it clear for anyone using the document how the terms are intended to be interpreted. So one of the changes that's been proposed is to increase the number of terms that are defined in order to improve interpretation of the document and to make it easier to consistently interpret. The existing land use bylaw has 196 definitions and the draft includes 321. So it is a substantial change, but the intention is to make it easier to understand, and it also improves the defensibility of the document in the event that there is conflict in terms of interpretation. So the new types of terms that have been added are technical terms, and then there's specific use terms that relate to use classes that are enabled in the different districts in the land use bylaw. An example of a technical term would be buffer or lot grading and drainage plan or geotechnical report or height. Some of those terms have been defined because they are things that might be asked for as part of an application requirement. And it's easier for a developer within the community to assess costs, project costs, and their timeline for doing their development, if they have a clear understanding of what they might be asked to provide as part of an application early on in the process. So these are the sorts of changes that the addition of these terms are intended to facilitate. The next section deals with the amendment process. So land use bylaws are by their very nature living documents. They do get updated or amended, sometimes quite regularly, sometimes less regularly, depending on what the development pressures are within the community. But it's anticipated that they will be amended from time to time in order to reflect changes related to development trends or changes proposed by landowners within the community who'd like to do something different on a parcel of land than the land use bylaw currently allows. So some of those amendments are driven by the municipality, identifying a change that needs to be made, and sometimes they're driven by developers who'd like to facilitate a change. So this section that's been updated has been updated to identify who can apply for amendments to the land use bylaw, what the process is when an amendment is received, and then a little bit more additional information about what happens once that process is undertaken and what the requirements are for engaging with the community. So things like public open houses or public hearings that are requirements when a municipality is considering making a change to a document like this, a bylaw like this. Section 5 deals specifically with development permits and the development permit process. This section's been updated to describe the process for and reviewing of development permit applications. It's been pretty significantly updated to reflect more modern application requirements and to be more transparent with the development community about what might be asked for to accompany those applications. This section has also been updated to reflect provincial legislative changes and to ensure that development occurs in a manner that supports economic development within the community and that it's timely and that the approvals can be issued in a timely manner. Within section 5, there's a couple of subsections that we think it's important to draw your attention to. 5.1 relates to the control of development. This section identifies when a development permit is required for a change of use or building or construction on a lot, and it identifies the responsibilities of the development proponent. Section 5.2 is the section that identifies what types of developments do not require a development permit within the community. Just in terms of keeping things, I guess, a little bit simple, essentially, if what you want to do within the town of Gibbons on your lot is not listed in the list of development not requiring a permit, then it likely needs a development permit. And it's worth inquiring with the town regarding whether or not a development permit is required. So that's one of the first places maybe to look when you're trying to determine procedurally what you want to do. If you want to do development in the community, you look to section 5.2. And if what you want to do is not listed there, is not requiring a permit, then you reach out to administration and begin that process. Some of the changes made to this section, this development not requiring a permit section, include the addition of adding to the list of developments not requiring a permit things like renovations that would not require a building permit, temporary signs on an active development or construction site relating to that development or construction, extensive agriculture on larger lots in the urban reserve district, because there is a little bit of agricultural land within town boundaries, minor home occupations, and then things like fire pits that conform to the town's community standards bylaw. Part 5.3 provides guidance regarding what happens when there's a development on a lot that's a legal non-conforming building or use of a parcel. And those are things that development permit has been issued for, and then in some instances, the bylaw has changed in some capacity, but they were legal conforming developments prior to that change in the bylaw. And this section just carries forward information about the right of the landowner to continue to use that building in that capacity, in that location, carrying forward, even though there's been a change to the bylaw. Their existing permit does not expire. 5.4, general development permit application requirements, provides information about what types of things must accompany a development permit application. So there are a few additions to this list that we wanted to flag for your attention. The list includes scaled site plan. so that it's easy going forward, I guess, for everyone to tell what has been proposed and what's been approved, pre and post construction site and building elevations, the required application fee, and in some instances, a real property report, just in order to ensure that both the landowner or developer and the town have a clear understanding of where the building is being situated on a parcel. Sometimes it's hard to tell, even on a developed lot, where the parcel boundaries are. Sometimes fence lines aren't developed where we think they're developed, or they don't reflect the boundaries of the parcel. And in those instances, it is helpful if you don't know where your pins are and you're not sure that things were constructed along parcel boundaries to have a real property report when you're preparing your site plan to ensure that your new development will be placed in the correct location. Sections 5.5 to 5.9 provide specific additional application requirements relating to different types of use classes. Where additional information is required that is specific to that use class in order to assess the suitability of that type of use in the location that's being proposed. So examples include alcohol retail sales or cannabis retail sales, industrial developments, commercial or recreation developments, or alternate energy systems. 510 provides information about what's required to accompany a development permit for demolition. At its most basic, if a building requires a development permit to go up, it likely requires a development permit to come down. So that's just by rule of thumb, but this section provides a little bit more specific information about what the triggers are for those permits and what would be required to accompany the application. 511 is a new section that was added after changes to the Municipal Government Act that require all municipalities to identify within their land use bylaw how they will provide notice to an applicant upon receiving an application for a development permit, whether or not the application is complete or incomplete. Municipalities have 20 days from the receipt of an application to make that determination and to reach out to the applicant to let them know. And this is just important for tracking timelines so that an application doesn't come in and then sit in a municipal office for too long without there being correspondence between the applicant and the municipality to ensure that things can move along in a timely process. So this is a required addition to the land use bylaw to address that change to the legislation. 512 development permit notifications has also been updated to reflect some changes to the Municipal Government Act or MGA relating to development permit notification processes. And then 513 conditions and development agreements has been adjusted or amended and expanded to provide more clarification about what types of conditions might be applied to different development permits for different uses, so that that information is transparent to anyone who is making an application for development within the town. Section 514 addresses when a permit becomes valid and when it comes into effect. And it provides some information about how long you have to complete your construction after a permit's been issued. This section of the bylaw hasn't been revised. It's just been maintained and carried forward. Section 515 isn't the variant section of the bylaw, and it is a new section. This section identifies when the development authority can grant variances to provisions in the land use bylaw. So sometimes you want to do development on your property and it isn't consistent with the building setbacks from the side property boundaries or front or rear property boundary. And sometimes it's a little bit over the maximum lot coverage percentage, or it exceeds the maximum height that's identified within the district. The development authority does have the ability to vary those maximums to some degree. And this provides information about what the considerations of the development authority would be in a situation where that type of development were proposed. And it helps identify what, I guess, conditions must be satisfied in order for the development authority to grant that variance. 516 just provides some information to clarify that approvals issued under the land use bylaw don't exempt a person from complying with other provincial or federal requirements for different types of permitting or approvals. And then we get into part 6, which is the subdivision section. So these are all the administrative parts of the land use bylaw that just have been expanded to provide a little bit more information about what happens when development is proposed within the municipal office, just to provide greater clarity to anyone who is proposing to do development within the community about what goes on when applications are received and what types of things might be asked for, or what types of conditions might be included as part of an approval for a development permit decision. Part 6, the subdivision section, is a new section for the town's land use bylaw. The processes that are outlined or procedures outlined in this section aren't new. The procedures and requirements for meeting legislative timelines and when referrals are required, those sorts of things, are currently being undertaken by the town's subdivision authority and subdivision authority officer, but the land use bylaw doesn't provide any information about it right now. So one of the changes proposed in the draft is to just provide a bit more information about what goes on with the subdivision process and what the requirements are, just to improve transparency again for anyone who is proposing a subdivision within the town. So this section identifies or outlines existing application requirements. It identifies the processes that the subdivision authority must follow in assessing applications, provides references to Municipal Government Act requirements for deeming an application complete or incomplete, and it clarifies the types of decisions that can be issued when an application is made. Part 7 provides information about the appeal process. So from time to time, a development or subdivision decision is issued, and either the applicant or landowner, or in development permit decisions, sometimes for some types of permits, for a development permit for discretionary use, for example, or where a variance has been granted, an adjacent landowner or someone who believes they're being adversely affected by the decision may want to appeal the decision. So this section provides information about what can be appealed and what those different appeal processes are, so that anyone who is affected by decision in a negative way has information about how that process can be undertaken. The processes for appeals for subdivisions and development permits are outlined in the Municipal Government Act, and they're the same for all municipalities. So this is just bringing some of the information from the legislation into the land use bylaw, because it makes it a little bit more accessible for people than having to go directly to the Municipal Government Act. But it's consistent with the legislation. And then Part 8 deals specifically with enforcement. So from time to time, a municipality is in a position where they have to take enforcement action to ensure compliance with the land use bylaw. So if development occurs on a lot without permits, and it should have had permits, and this section identifies the steps the municipality will take in order to ensure compliance with the bylaw. And then from time to time, development will occur in a manner that's inconsistent with an approval that's been issued, and the same sort of process would be undertaken. And normally, really what happens is municipality will reach out to a landowner when they become aware of a non-compliance issue and have a conversation and ask them to comply. And if the situation can't be resolved that way, then there's other steps that can be taken that generally relate to a ticket or a fine, or in the worst case scenario, a stop order, which through the courts requires the landowner to comply and just bring the property back into compliance with the land use law. So it's not something that happens very often with municipalities, and I guess important to note is that the enforcement section for land use bylaw, it applies only to matters that the land use bylaw regulates. So it's specific to the land use bylaw. It doesn't deal with anything outside of the scope of the land use bylaw. Okay, so those are the most boring parts of the land use bylaw, unfortunately, but also really, really important parts of the land use bylaw. They just deal with all the administrative functions relating to land use and development and subdivision within the municipality. The next section of the land use bylaw provides information about general land use regulations. So these are different types of development that can occur within the community that could occur within any district or on just about any lot. So they apply generally to the entire town. Within your existing land use bylaw, there's 24 different sections that provide general land use regulations. And this has been expanded in the draft to cover a few different things that, you know, as land use bylaw has been utilized, and we've had different experiences with issues that have arisen, especially as lots redevelop within communities, or your community, like your community that has this beautiful river valley running through it, we know we need to address those sorts of specific considerations in a different way. So in your draft land use bylaw, there's new sections that provide specific information about how development can occur on a corner site or corner lot, because there's different setback considerations in order to ensure traffic safety at the corner. Environmental considerations or screening requirements, how to address fences and walls specifically, protection from exposure hazards, site conditions and buffering requirements for some types of developments that, if they're right next to each other, can create a conflict, and then projections into yards. We've highlighted two sections here to focus on in a little bit more detail for you, because we think it's important that we draw your attention to the changes being proposed in those sections so you have the opportunity to provide us with feedback. So this new section, environmental considerations and screening, enables the development authority to require environmental site assessments to be conducted for a site with the potential for contamination as part of a development permit application, or where there's a potential environmental hazard identified on the site because of things like steep slopes, which are slopes that are greater than 15%, where we know there is the potential for a history of slope instability. And because of the river valley running through the community, there are areas within your municipality where this is a consideration. In some instances, there's lots of places where it isn't, but there's some places where it is, where there's a high groundwater table, because it could impact how construction occurs in the lots, or any areas that may be subject to floodplain or flood fringe considerations. So this section just deals with what might be required on lots where those particular features are present. It doesn't affect a lot of lots, but it does affect some within the community. The next section we wanted to flag for your attention is 9.11, which is fences and walls. Some of the proposed revisions in the draft bylaw include prohibiting the development of walls or fences that affect grading and drainage from one lot to an adjoining lot. So we found throughout the province, in different municipalities, that sometimes when redevelopment in particular occurs, but sometimes it's new development too on a greenfield lot, because of changes to the lot elevations to facilitate the new development, or because of proposed fencing or retaining wall features, it creates flooding issues on adjacent properties. So this is not often the case in new development areas where there's new subdivisions that are approved with stormwater management plans and lot grading and drainage plans that are part of those subdivisions. But in communities where the lots are a little bit older and those weren't requirements of the day, because we didn't know better then, we have to address development on those lots or redevelopment on those lots in a slightly different way, just to make sure that we don't inadvertently create a problem for the adjacent landowners. And the most common problems really are flood susceptibility or flood hazards, just because water gets backed up because a lot of elevations change. So this is why this has popped up in the draft, is to try and address a problem that has arisen within communities like Gibbons throughout the province. One of the other changes enables the development authority to require screening along boundaries of commercial or industrial developments when they're adjacent to residential areas. And this is to try and mitigate or minimize any potential off-site impacts on those adjacent properties because of the more intense use that is intended or expected to occur on that industrial or commercial property. So it's just some of these things are, you just would consider them to be a good neighbor type of things. But if we don't ask for that information and then condition it with the development permit with the development permit approval, then sometimes it doesn't happen. And then we have to deal with the consequences, which can be pretty detrimental to the adjacent property owners. Another example is changes or requirements for screening around garbage or loading facilities for commercial and industrial developments. And it's the same sort of thing. It's to minimize offsite negative impacts on the adjacent property owners, especially if they're residential properties. And the last one we wanted to flag for you relating to this section is that there's a regulation that would prohibit the use of barbed wire and electrical fencing in districts other than the industrial district or urban reserve district. And that's to just try to minimize potential, I guess, for kids in the community, coming up against these types of fencing and then being harmed in some capacity, but still enabling these types of security measures on lots where they really need to be there for one reason or another. In the urban reserve district, because some of those lands are still undeveloped and are utilized for agriculture, barbed wire makes sense, right, in some places. And then on industrial lots, sometimes they need these added security measures just to protect the industrial parcel and keep people out, to keep them safe. So have a look at those sections, and if you have any questions or concerns with what's being proposed, we'd like to hear from you. The next section of the document provides specific regulations that relate to different use classes that are identified as permitted or discretionary uses within the different districts. So this is another area where the land use bylaw has been expanded. The current land use bylaw has 17 different categories or sections that deal with specific use classes or special land use regulations for use classes. The draft has 40 different sections that provide specific regulations relating to 40 different types of use classes that are defined and then regulated in the land use bylaw. So anything on this list that's identified as red, those are new sections and provide new regulations that deal with different types of uses. And the reason this one's been expanded so much is that we have different types of developments occurring within urban and rural municipalities in the province than we had when your existing land use bylaw was approved. So, for example, we are having more interest in development of things like microbreweries and distilleries, industrial hemp, alternate energy systems, CCANs or shipping container usage is much more prevalent in the last 10 years than it was before that. And then suites, so garage suites, garden suites, tourist homes, which are things like Airbnbs. Those are different types of uses than we had defined and regulated in land use bylaws, because we weren't seeing them as much as we're starting to see them now. And now that we are starting to have pressure for those types of developments in the community and want to see some of those types of developments within the community, we have to figure out how to regulate them to minimize negative impacts on the neighbors again. And really that's the intention of any of these provisions, is to try and figure out how to allow the things that community members want to see without having a negative impact on their neighbors. So I want to draw your attention in the next couple of slides to those areas or those sections that we've flagged in yellow. The first one is event venues, and there's been a lot of interest in developing event venues within this region, particularly in rural areas, but in some of the smaller urbans as well, or adjacent to. And they're awesome. They're great to see within the community, but they also, if they are not designed appropriately, can create impacts that affect not only adjacent properties, but municipal infrastructure that then result in unanticipated costs for all of you who pay your taxes within the town as you have to deal and respond to those impacts on infrastructure. And the biggest one is roads, right? If someone's business, their small event venue becomes very successful, which everyone would like to see the business become successful, and we didn't ask for things like a traffic impact assessment, then from time to time we can end up with requirements for improvements to the road itself or an intersection, which somebody has to pay for. And if we didn't condition that as part of the development permit application, then it becomes a responsibility of the municipality, which means you all end up having to pay for it in some capacity. So we have learned, I think, through some of our mistakes, what types of information we should be asking for to accompany these types of applications, so we can get on top of some of those potential impacts and make sure that we're not allowing development to occur that then results in additional costs to the rest of the folks in the community to facilitate, I guess, the impacts of. So the requirements for an event venue, so wedding venue or conference facility or something like that, that would be expected to accompany the application include an operations plan, traffic impact assessment, an emergency response plan, a noise impact assessment, community consultation plan to see how the neighbors feel about that. And then there's an opening there for any additional information the development authority might deem necessary just to address the specific site considerations. So we've defined this use class. We've provided some specific regulations to address potential negative off-site impacts. And then we have enabled this type of use to occur as a permitted or discretionary use in the CRX district, which is the mixed use district, the C1, which is commercial district, C2 commercial district, and M is an industrial district within town. So now it's listed there, and it could occur if it's an appropriate site and these types of issues have been addressed to the satisfaction of the development authority. The next one we wanted to flag for you was the section that relates to manufactured homes. In the draft land use bylaw, manufactured homes are restricted to manufactured home parks. So that's the residential manufactured home district, the RMH district. New manufactured homes that are coming in, so this doesn't apply to ones that exist within the community anywhere today, but if a new one were to be applied for, a new development permit were to be applied for a manufactured home in town, then that manufactured home must provide proof of having Canadian Standards Association certification. It must be constructed within the last 10 years of the date of the bylaw being approved and the time of the development permit application. And then the development authority has the ability to consider applications for older manufactured homes if they're of sound construction and compliant with the appearance and design building regulations in the bylaw. And what sound construction means and compliant means is it has to be able to satisfy current Canadian Standards Association certification. So it has to meet current code requirements. And then there are requirements for skirting to the ground level to match the external finish of the manufactured home, just to ensure the appearance of the manufactured homes is appropriate for the appearance of other buildings within the community. Section 10.8 provides regulations regarding sea cans and shipping containers. So this is another thing that when the previous land use bylaw, the one that's in effect today, was developed, we weren't even really thinking about sea cans and shipping containers, but now they are a common occurrence, and there is a lot of demand for them on different parcels within different municipalities. So they have been enabled in some locations within the community with some regulations to ensure that where they are allowed, they are the appearance of these structures is appropriate for the lot that they're being requested to be placed on. So where a development permit application for CCAN is applied for, the developer must provide evidence that the CCAN is in good repair. It has to be clad to conform to the character of the surrounding developments. There's a maximum height of 3 meters, and a maximum length of 6.1 meters. They must conform to the setback requirements for any other type of accessory building within the district, and the maximum number that can be placed on a lot for temporary basis in the front yard of a residential lot is 1. And those are the types that you see that are brought in and dropped on a property during construction, or if you're moving, something like that, and the CCAN or shipping container is plopped on a driveway, you put all your things into it, and then someone comes and picks it up and takes it away. So those are pretty common, and the town wanted to ensure that type of a CCAN would be allowed for those types of purposes. But then there's other situations where people are requesting a CCAN to be placed on the lot permanently, and those are the ones that can be a little bit more problematic if they are not in good repair, or they're placed in a location where they create a wall that makes it uncomfortable for the adjacent property owners to be beside. So that's regulated now in this new section, and then there's a final provision there that talks about ensuring that CCANs are not used for human or animal habitation. So have a look at this section too. The only other thing I wanted to point out is that, whenever we talk about CCANs, we just sort of talk about CCANs as a CCAN, and a CCAN as a building material that gets utilized for some different type of end use building. So for example, there is a hotel in Bruderheim that is constructed out of CCANs. From the exterior of that hotel, you would never know that they had used shipping containers as part of the construction material for the hotel. It looks like a regular stick-built hotel. When a CCAN is utilized as a construction material for a different type of end use, and the building itself meets the building and safety codes requirements for that different end use, and it doesn't look like a CCAN anymore, it is for the purposes of the land use bylaw not considered a CCAN. So there is a bit of a fine line between what is a CCAN and when a CCAN is utilized as a building material for a different type of end use building. And if you're thinking about utilizing secans for something else, so not for storage, then it's worth having a conversation with your building and safety codes inspector through the town and also the town's development officer to try and figure out whether or not your development permit would actually be for a secan or if it would be for something else, and then sort of working through that in your specific situation. So the next section that's a new section that we wanted to flag relates to garage suites. Your existing land use bylaw doesn't specifically address garage suites and have regulations for them. So this was something that we wanted to improve upon in the draft. So the draft land use bylaw does enable the construction of garage suites on a lot that has a single detached dwelling. So it has to be a developed lot already. The garage suite can't be the first thing that's constructed on the lot. It has to remain secondary or subordinate to the main dwelling on the lot. And one of the ways that we ensure that is to have a maximum size for the suite itself. So the area of the suite can't be bigger than the area of the house on the lot, and it can't exceed 860 square feet. It can include cooking facilities, bathroom facilities, and then sleeping facilities. So it can be a standalone dwelling and have all of those features. And it must have an entrance that's separate from the garage space, and there must be parking provided on the lot in addition to the minimum number of parking stalls required for the dwelling on the lot too. So it has to fit on the lot without creating an offsite impact that would affect adjacent landowners because say there's some stuff parking or something like that, because that can create conflicts between neighbors. So that's a new section we'd like you to review and see whether or not the regulations in there are appropriate for your community. They're pretty standard, so there shouldn't be a conflict there, but we'd like you to have a look at that. Garden suites are another type of suite or development that we're seeing in areas, especially because the cost of housing is so high right now. And we wanted to, in discussions with administration and council, enable, I guess, multi-generational living on a lot too. So it's not just providing some more affordable housing options within the community, but it's also enabling, if you've got a kid who's almost ready to leave, but not quite ready to leave, or you've got aging parents who you'd like to have a little bit closer, sometimes these different suite options are good options for them. And a garden suite, especially if you've got aged family members, is a better option than a garage suite because you can do them on the ground level and you don't have to deal with the stairs. So this is something that different municipalities are contemplating and starting to enable in their land use bylaws to address some of these housing pressures or concerns that we know that we're facing within our communities in Alberta. So this use is defined now and enabled in the land use bylaw, and then it's got similar regulations to the regulations that affect garage suites. So you can have one, maximum of one, that has to remain secondary or subordinate. They can't be too big, otherwise they're a second full house on the property, and that's a bit much for the neighbors. They have a maximum height. They can have cooking, bathroom, and bedroom facilities. They have to have a separate entrance, and you have to provide parking on your lot. So the only additional regulation that relates to this type of a suite, I think, is regulation that indicates that they can't be subdivided from the principal dwelling in the future through a condominium conversion or regular subdivision. So they're intended to be part of one lot, not two lots that then get further subdivided down the road. And for the time being, that's the most appropriate thing to do. I know there are other communities, say in British Columbia, where these were developed 20 years ago, 10 years ago, and now the housing pressures are so intense that they're starting to see some pressure for subdivision, but we're not there yet. So we're in that sort of earlier stage where we're just starting to enable these types of things to occur because we need them. And then we'll see how it goes down the road and how many are developed and whether or not we have to contemplate, additional revisions to minimum lot areas to address future housing pressures. So this is another one that when the land use bylaw that's currently in effect was approved was not contemplated. We didn't have or couldn't have anticipated the types of interest there would be in tourist homes or Airbnb or VRBO types of developments within different communities. And so they weren't identified and regulated within land use bylaws. And what that means really is that they were not enabled. And now that we have a better understanding of the desire for them and some of the positive and negative impacts around this type of development, it's important that we do regulate them through the land use bylaw to try and enable them where it's appropriate to do so, and then minimize the potential offsite impacts or problems that can occur if they're not regulated properly. So the draft land use bylaw does include this as a use class. The tourist home term is intended to include things like Airbnb or VRBO, any of those short-term accommodations, types of uses that occur within single detached dwellings or residential properties. Um, the regulations that have been identified include the requirement for development permit annually. Um, a maximum of one tourist home is allowed on a lot. So if you had a house on your lot and a garage suite, both units could not be VRBO'd or Airbnb. You can only have one. Requirement to display a copy of your development permit identifying the maximum occupancy in the building and having a home safety and evacuation floor plan available for guests. We've identified maximum occupancy requirements within the provisions here, so with the expectation that you could allow up to a maximum of 8 adults within a VRBO or Airbnb type of accommodation. The children under 12 are not included in that occupancy maximum. It's hard to limit the maximum number of children in a way that would be appropriate, but really the children aren't often the issue with some of these types of developments. It's more when they get rented out for a large adult party, and that's when we see some of the more negative impacts. So that is a regulation that's been identified in the draft we'd like you to have a look at. And then there's a requirement to comply with Alberta Health Inspections requirements too. Okay, so that's like those are the major changes to the document. This land use bylaw was not extensively revised. We just did a focused review of the land use bylaw to try and address those things that have come up as an issue in the last little while, and then it was focused or targeted to address those legislative updates that I discussed at the beginning of the presentation that have just occurred. You know, the province has done and the municipalities have to respond to, and then to consolidate all the amendments to make the document easier to use consistently and to understand, both for members of the community and for administration as they're working through the document. It's really hard when you've got 50 amendments and they're not all in the online version of the document to really know what it is that you can do or cannot do. So those are the things we really focused on in the land use bylaw. The last thing that was updated and identified as a priority was to just try and simplify the districts. So the existing land use bylaw has a lot of residential districts in particular, and we would argue that it's got more than it needs. And I think the history of that likely comes from the fact that there has been different development pressure from different like large developers who wanted to do things that are slightly different than were enabled by, say, the R1 district. And so they brought forward an R1A district to enable the slightly different thing. And then someone would come forward with another slightly different thing that didn't comply with the R1 or the R1A district, and it became a new district again. And then the developments either didn't occur or they did occur, but they were so close that it just seems a little bit silly going forward to try not to just address all of those things that the town has and likes and wants to encourage within very slightly different types of zonings. So instead of having 4 R1 districts, 5 R1 districts, the draft includes 2 R1 districts. So one that would encompass all of the different minute differences between the R1 and the R1C district. And then the innovative design district was kept as a separate district because it is a little bit more different than those other 4 districts. We also are proposing condensing the 2-family residential district and the medium residential district because they're so similar, just easier to have them condensed as well. And then the other ones were left the same. So it's an attempt at simplifying the land use bylaw to make everything a little bit more consistent and everybody to have more equal development rights within their different lots within the community, and enable those types of developments that have been occurring that the community wants to see continue to occur in the past or in the future. There were some commercial districts that were condensed as well. So the commercial industrial direct control district and the highway commercial district. And then Gibbons has a number of direct control districts, more than we think are maybe necessary going forward too. And so some of those direct control districts have been removed, and those lots we're recommending just become regular R2 lots, which is residential lot, type of residential lot. For your, I guess, information, just in case anybody hasn't heard of a direct control district before. The difference between a direct control district and other types of districts is that within a direct control district, the development authority is council. In other types of districts within the land use bylaw, the development authority is the development authority officer. So it's either the CAO or the development officer, depending on the type of development that's been proposed, because that's how your development authority bylaw is set up in the town of Gibbons. But for the direct control districts, those decisions are made by council. And the most important difference, I guess, between council making a decision about development and the development authority making a decision about a development is that if council makes a decision about development, then your appeal right disappears. So we like to use direct control districts very sparingly because we want to ensure that community members have the right to appeal those types of uses or developments within the community that may be negatively received. So they are a good tool from time to time for innovative types of new things that might be proposed and you're just not sure whether or not you want to see them all over the place. So sort of like a site-specific zoning, but we have to be really careful with them too, because we want to be careful about where we remove your appeal rights from, because you should have the right to appeal development that negatively impacts you. So those are the most, I think, significant changes that have been proposed to the districts, and we invite you to have a look at the districts in the draft bylaw and let us know whether or not you have any concerns with anything that's been proposed there. This slide just has a side-by-side, I guess, of the existing land use district map within the approved land use bylaw and then the draft land use bylaw map. And you can see where the annexation area on the right side of the map, on map to the right, that's the draft map, has been expanded to include those 3/4 sections that were annexed. I want to point out that the current land use district map that we've identified there does not identify all of the amendments that have occurred. It is an older map, yeah, thank you, Brad, and it doesn't identify all of those site-specific zoning amendments that have occurred since the map was approved. It does have some of them, but not all of them, because you have to go back and keep doing it, and sometimes it's hard to keep up with that. I think the intention going forward, now that the municipality is more accustomed to utilizing GIS mapping software, is to make sure that any time an amendment is approved, that the map gets updated. It's an easier thing to do now than it was before. We used to have to send them out to the engineer to update, and there was some cost associated with that, and then some time and cost. So it was a little harder to do than it is today. So there definitely are some differences between the two maps. We'll make sure that this is posted on the town's website as well, so you can see that, and just have a look at where your property is and have a look at the properties adjacent to you, so you can see if there's a difference being proposed, or if it's the same, and you can familiarize yourself with what your zoning of your own property is, so you can have a look at the provisions within the district that apply to you, in case you have any questions or concerns about what's in there, so we can have a conversation with you about that and see if we can answer those questions for you or address any concerns. So that is, an entire land use bylaw in an hour. It's a lot. What we really intended to do tonight was to just provide you with some information and flag some areas that we think are really important for you to have a look at as you do your own review of the document. We want to also invite you to come out if you have any additional questions, or you joined us late, or you want to come talk, I guess. On Saturday, we are having an in-person open house where we will go through the same information, and we'll be there to answer any questions. It'll be at the Gibbons Cultural Center, and it will be between 10 a.m. and 1 p.m. After that meeting, we'll put together a summary of all the feedback that we've received. We'll send that off to council so that they hear directly from you. And then we're anticipating that, if there's some feedback that results in recommended changes to the document to reflect any concerns that come up, we'll take those to council, and we'll make any changes that council directs us to make based on your feedback. And then we'll revise and update the land use bylaw to reflect that direction from you and then through council to get the document ready for consideration at first reading. Because it's a bylaw and it's approved by bylaw, the process is to have first reading of the bylaw, to send out notification to agencies and adjacent municipalities, and then to provide notification to the community about a public hearing. So This meeting and then the meeting that will be on Saturday are pretty informal engagement sessions. Any of you who've been to a public hearing, that's a little bit more of a formal engagement opportunity for community members. So that would be in chambers normally as part of a council meeting where community members are given the opportunity to provide testimony to council directly, indicating what you agree with or what you object to in the bylaw so that they're hearing from you directly, or you can provide written feedback if you're more comfortable doing that. It isn't a question and answer type of situation. The session on Saturday coming up, we have the opportunity to just have a conversation. The public hearing is your opportunity to give testimony to council. And then council will carefully consider any feedback that they receive during the public hearing. And depending on what is presented at that time, they may direct additional changes to the bylaw before it's brought back for consideration of second and third readings. So we recognize that the land use bylaw is a long document. They always are, unfortunately, out of necessity. So we were not anticipating that before this evening, you necessarily would have had the opportunity to review the document. So we are kindly asking that you have a look at the land use bylaw following tonight's meeting if you haven't had a chance to before, and to provide us with your feedback by February 28th so that we can compile those comments and get them to council for their information so that they have your feedback before we get into that final stage of the project, which would involve the readings of the bylaw. We put Brad's email address on the bottom here of this slide. If you're more comfortable, you can also send your comments to Susan at the town and she'll get them to us too to compile. But please do reach out either to Brad or to Susan, and Susan is the planning@gibbons.ca. And one of those two fine folks will get them to me, and we will all compile them and get them back to council, because ultimately bylaws are approved by council. So we provide recommendations, but council is responsible for approving the bylaw. So they're the folks that need to hear what you have to say. So we want to thank you very much for joining us this evening. Brad, is there anything that I missed that we need to add?
Yeah, thanks, Jane. I'll just note for the open house coming up on Saturday, the in-person one, it is 10 to 1, but it's drop-in style. So if you feel like coming in at 10 o'clock or 10 minutes to 1 o'clock, anytime during that period, you can come in and ask specific questions, or we can give you a bit of a rundown on parts of the land use bylaw that are relevant to you.
Yes, and I will add too that the presentation this evening has been recorded. So we will be providing a link on the town's website to the full recording. So if you joined us late or you had to jump out or only caught part of this presentation, the full recording will be available on the town's website for you to listen to. Or if you have friends or neighbors that didn't have the opportunity to attend this evening and can't on the weekend, this will be there for them to view as well. So just let them know that it's available, and we encourage you to spread the word for us so that we can make sure that the community is aware that this is going on and has the opportunity to provide us with your comments before we get into the final stages of this project and are providing recommendations to council. So thanks to all of you who joined us this evening. We really appreciate you taking time out of what I'm sure are your very, very busy lives to spend some time with us this evening. Looking forward, hopefully, to maybe seeing some of you on Saturday as well.
Yeah, Jane, we've not had any questions in the chat as we kind of go through a lot of this information, but if anyone has any questions at this time, you can either put them in the chat or just indicate that you do have a question. We can perhaps provide the opportunity to unmute or individuals if they have questions that they prefer to ask vocally, if that's much easier than in typing it out in the chat box. We kept everyone just unmuted or muted here for the purposes of just avoiding any accidental interruptions or anything that might affect the recording here. So if you do have questions, you can either direct them to me in the chat or just kind of there should be a hand raise button that you can use as well. So we'll just leave that open for a few more seconds, and then we'll have Jane conclude the open house here. I'm not seeing any come in here, Jane, so if you want to kind of close this up.
Okay, well then I'll thank you one last time, everybody, for joining us tonight. We're looking forward to hearing your feedback on the draft document and maybe hearing from you over the next month. So everyone have a wonderful evening. Thank you very, very much.